Hello, my name is Andrew Miller and I'm a partner with MPL law firm. I am the lead partner in our renewables practice group. We are often asked in our renewables group, what is the difference between a zoning use and a land use code? The terms are completely unrelated but cause a lot of confusion. A zoning use refers to the allowed use of land under a zoning ordinance. Parcels of land typically exist within a zoning district on a zoning map. The zoning district corresponds to a section or chapter of the local or county zoning ordinance that sets forth the allowed uses for the land. Usually, multiple allowed uses will be listed out in the zoning ordinance for each zoning district. Each of those uses may be allowed as a permitted use, special exception use, or a conditional use. Many of those uses will then also have special regulations specific to the particular use. The zoning district will also have dimensional regulations for lots and densities. The zoning use, therefore, regulates where and how land can be used. A land use code, quite differently, refers to the classification of the existing land use on a parcel of land. The land use code is used for tax assessment. Land is valued and classified by its actual use for purposes of tax assessments and ultimately real property taxation. A parcel's land use code is independent of the zoning. Many times land may be classified as residential or commercial in an agricultural zoning district, or may be classified as agricultural in a residential or industrial district. The land use code does not change what is allowed on the land. The land use code only reflects the use and value of the underlying parcel for tax purposes. Land use codes are generally categorized very broadly. In fact, many counties do not even have land use codes for many common uses such as solar, wind, energy. In those cases, many counties use other codes such as commercial or industrial to value the land. While this may sound simpler, the result is that many renewable energy projects for wind or energy end up being overassessed because commercial or industrial land has far more value than land leased for a solar or wind project. Also remember that in Pennsylvania, the value of equipment installed on site is not assessable or taxable as an improvement to real property. We always recommend renewables developers and landowners pay attention to the land use codes assigned to the land hosting the projects. There may be very real opportunities to appeal the assessed value where a general land use code has been assigned. If you have any further questions or believe the land that your renewables project is sited on may be overassessed, please contact me or any of our renewable energy attorneys at MPL Law Firm. Thank you and have a very great day.